Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, just dropping in to say we're now on Patreon. If you want to support the project, head on over to patreon.com/legallistening, where you can unlock some fun bonus content with me, Zach, and some special guests. Thanks so much for all your support. So today on the podcast, we have something brand new and very exciting. So instead of just having me and Zach jabber away, we have a special guest to tell us about our decision today. We have Bennison Smith, who's of our cohort at Windsor Law. And we're so excited to get him on the pod to talk about some family law. So, Bennison, what are we chatting about today?
Hey, guys. Thank you so much for having me on the pod. Longtime fan, and it's kind of great to be back. So, today we are chatting about a family law decision from 2002. It is the Attorney General of Nova Scotia and Walsh. And I just was going to chat with you guys a little bit about the decision. I just wanted to also chat a bit about the dissent by Justice Leroux Dubé, because it's interesting. It was the bench was 8-1 on this decision in 2002, and Justice Leroux Dubé was the only dissenting voice, and she had a lot to say, as you'll hear in the recording. And I just had some quick notes to wrap us up as we talk about the decision.
Cool.
Yeah, sounds good. Take us away.
Okay. So, to start off with, talking about this decision, I wanted to get it out of the way and mention that this is technically not quote-unquote good law anymore, as they would say in law school. So, for the good law version of this fact pattern, you'd want to take a look at the Attorney General of Quebec and A, which was a 2013 decision. I think it's also known as Eric and Lola, a little bit colloquially. But Walsh, the Walsh decision we're chatting about today, it's still a very influential case in family law. I think it's taught pretty broadly across all law schools, and it's just, I think, a very good decision to kind of sink your teeth into family law concept a bit. And listeners will note from the factual background of the case, maybe once they hear it, that this is probably a similar fact pattern that you would find in law school hypos. And, if you get to know the facts of this case, it's pretty applicable to something you might encounter in a hypo at law school. So the decision itself, of course, being family law, it's concerning matrimonial property and how it's divided upon separation under Nova Scotia's Matrimonial Property Act of the time in 2002, the MPA it's called. And in particular, in this Walsh case, it concerns an unmarried common law couple. So these folks are not married. They've been cohabiting for a while. And then, unfortunately, the relationship ends, and they're trying to divide the property that they accumulated over the course of their relationship. So property division regimes for cohabiting unmarried couples like these ones, that are in the process of separating, as I understand it, it's a bit of a patchwork across the country. So different provinces will treat these issues a little bit differently. There might also be child support or spousal support issues that arise, but in this one, it was pretty strictly concerned with the property and how the property is divided. So just a couple more quick notes on it. Basically, the court, and it was Justice Bastarche who was writing for the court, they were concerned with balancing, as I understand it, protecting an individual's right to choose and autonomy over how people might choose to structure an interpersonal relationship, like marriage, common law, whatever they might choose, on the one hand. The court was also concerned about protecting a vulnerable spouse or a vulnerable common law partner, in a situation where there's a power imbalance. And so the court, in the end, in this case, decided it would be overstepping itself a little bit if it imposed a property division regime that was applicable in black letter law to married spouses, and it felt like it would be overstepping itself if it applied it to common law spouses as well. So The court, just as a note for listeners, is also discussing the Myron and Trudel case pretty extensively, so might be useful for listeners to take a glance at Myron as well, just to get familiar with that one. And I thought, I was just talking to you guys a little bit before we hit the record button, and I kind of thought this was interesting that we were just talking about, living with your common law partner or living with your married partner. I thought maybe you guys wanted to weigh in on that.
Yeah, that's a funny one. The whole division of property thing, Erin and I used to joke about, Erin being my now wife. We lived together when I was in law school, and we didn't, I think we achieved common law status for 2 weeks before we got married. Anyways, we would joke as to who would take the Nintendo 64 and who would take the Xbox. Those were the things that, you talk to your common law partner about when you're in 3L taking family law, because you're like, oh, guess what I learned at school today? Like a kid.
Yeah. Plus, especially, I don't know, at this point, it's, my husband's American, so we got married and then he got permanent residency, so we never lived together as common law couple. But I guess at this point, it's almost like, do you want a percentage of my debt? Because, I don't know how asset rich I am at this point in my life. So, yeah, it's funny because, obviously, this case, the way you're describing it, brings up a lot of sort of broader reaching stuff, which is very interesting. But it's always funny too, especially with some of these family law cases, because I, as a model middle millennial, can't even fathom owning enough things to have it be a fight over the division of those things. So it's always very strange to me to see family law decisions when people are fighting over these assets and stuff, when it's just to have an asset.
Yes, it reminds me when we talked.
Must be so nice.
When we talked about that employment law. Did we do Bardol?
Oh, yeah, Bardol, yeah.
Stock options. I don't know what that is.
It's what are those? What's a pension? Oh, my God. Very similar vibes. But it does sound really interesting, though.
Yeah.
Okay. I was going to say, Bennison, do we have anything else we want to mention about this one?
Real quick, I'm just going to mention to listeners about the dissent by Justice Leroux Dubé, because it's kind of an interesting listen. And basically, this is a long, extensive dissent, maybe, in my humble opinion, a little longer than it needed to be, but that's okay. And basically the justice is holding nothing back in her dissent. And maybe that's why it's so long. Just because, the dissent takes up so much of the recording, as people will note once they listen. But yeah, Justice Leroux Dubé, she really does her homework in that dissent, and based on her references to previous decisions of this nature that she herself wrote, it's not the first time that she was out of step with what the rest of the bench was thinking, and I just found it really interesting because I think modern day listeners hearing her reasons, they might kind of note that she actually did a really solid job of kind of gauging and predicting where Canadian society would go from there, around norms involving cohabitation, outside of marriage and marriage itself as an institution. She has some really interesting thoughts, so I just thought I would maybe encourage listeners to stick around for the dissent as well on this case.
Fantastic.
Okay. Yeah, that sounds good. We always stand a Leroux Dubé dissent. So, well, thanks for doing the intro with us, Bennison, and enjoy, guys.
The Attorney General of Nova Scotia and Susan Walsh and Wayne Bonner, indexed as Nova Scotia AG and Walsh, heard at the Supreme Court of Canada on June 14, 2002, on appeal from the Nova Scotia Court of Appeal. Reasons given by Justice Bastache, concurrence by Justice Gontier, with dissent by Justice Leroux Dubé. Introduction. This case involves a charter challenge to the Nova Scotia Matrimonial Property Act, or, quote, the MPA, and asks whether its failure to include unmarried cohabiting opposite-sex couples from its ambit violates Section 15 Sub 1 of the Canadian Charter of Rights and Freedoms. The challenge revolves around the definition of, quote, spouse, end quote, in Section 2 Sub G of the MPA, which is limited to a man and a woman who are married to each other. The question before this court, then, is whether the exclusion from the MPA of unmarried cohabiting persons of the opposite sex is discriminatory. In my view, it is not. The distinction chosen by the legislature does not affect the dignity of unmarried persons who have formed relationships of some permanence, and does not deny them access to a benefit or advantage available to married persons. It is, therefore, not discriminatory within the meaning of Section 15, Sub 1. Factual background. Susan Walsh and Wayne Bonner lived together in a cohabiting relationship for a period of 10 years, ending in 1995. 2 children were born out of this relationship in 1988 and 1990, respectively. Walsh and Bonner owned a home as joint tenants, in which Bonner continued to reside after the separation, assuming the debts and expenses associated with the property. In 1983, Bonner received as a gift from his father a cottage property, which was sold after separation for $20,000. Approximately $10,000 was used to pay off the respondent's debts. Bonner also retained 13 acres of surrounding woodland in his own name, valued at $6,500. The total value of assets retained by Bonner at the date of separation, including the house, cottage, lot, vehicle, pensions, and RRSPs, was $116,000, less, quote, matrimonial, end quote, debts of $50,000, for a net value of $66,000. The respondent, Walsh, claimed support for herself and the 2 children. She further sought a declaration that the Nova Scotia MPA was unconstitutional in failing to furnish her with the presumption, applicable to married spouses, of an equal division of matrimonial property. Her claim for a declaration was rejected by the Chamber's judge, whose decision was reversed on appeal. My colleague, Justice Leroux Dubé, chooses not to make reference to the Law Reform 2000 Act, or the, quote, LRA, end quote, in the course of her analysis. I mention it as a new contextual consideration, but, as will become clear below, my conclusion on the constitutionality of the MPA does not depend on the existence of the LRA. In response to the Court of Appeal judgment, the Nova Scotia legislature introduced legislation, Bill 75, an act to comply with certain court decisions and to modernize and reform laws in the province, now the LRA, on November the 6th, 2000, that effectively amends the definition of, quote, spouse, end quote, to, quote, common law partner, end quote. Heterosexual and same-sex partners are both included in the definition of, quote, common law partner, end quote. And these may be either registered under the Vital Statistics Act or unregistered. Only registered partnerships are eligible for the benefits of the MPA and other legislation, LRA. Walsh's counsel advised the court that subsequent to leave to appeal having been granted, Walsh and Bonner have settled the litigation between them respecting the division of property. Relevant statutory provisions. Matrimonial Property Act. Section 2. In this act, sub G, quote, spouse means either of a man and woman who, 1. are married to each other, 2. are married to each other by marriage that is voidable and has not been annulled by a declaration of nullity, or 3. have gone through a form of marriage with each other in good faith that is void and are cohabitating or have cohabitated within the preceding year, and for the purposes of an application under this act includes a widow or widower. Section 12, sub 1, where a petition for divorce is filed, b. an application is filed for a declaration of nullity, c. the spouses have been living separate and apart and there is no reasonable prospect of the resumption of cohabitation, or d. one of the spouses has died, either spouse is entitled to apply to the court to have the matrimonial assets divided in equal shares, notwithstanding the ownership of these assets, and the court may order such a division. Canadian Charter of Rights and Freedoms, Section 15, Sub 1. Every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination, and, in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Judicial History. A. Supreme Court of Nova Scotia, 1999. The matter came before Justice Halliburton as a charter application, as the respondent Walsh alleged that she had suffered discrimination under the MPA because the presumption of equal division of matrimonial property applicable to married spouses did not apply to her as a common law spouse. Instead, the onus was on her, by way of constructive trust, to prove the extent, if any, to which she might have been entitled to a share in property held in Bonna's name alone. Justice Halliburton first considered whether there was discrimination under Section 15 Sub 1 of the Charter, noting that the section prohibits discrimination on the basis of certain personal characteristics. Applying the analysis sanctioned in Myron and Trudel, 1995, then in M and H, 1999, he first found there was no question that married and unmarried spouses are treated differently with respect to the onus of proof required to establish an interest in property under the MPA. Next, Justice Halliburton considered whether the difference resulted from discrimination as defined by Section 15 Sub 1 on the basis of an enumerated or analogous ground. In Myron, this court held that an unmarried spouse was entitled to insurance benefits because she had lived in a relationship analogous to marriage. Justice Halliburton noted the strong dissent in Myron and distinguished it on the basis that it involved all-encompassing legislation, to which the distinction complained of was incidental, whereas in the present case the distinction is specific incident governing the rights of married persons to a division of matrimonial property. Quote, secondly, the contest is between the parties themselves and reflects directly their decision, whether individually or jointly, to marry or not to marry. End quote, paragraph 17. Justice Halliburton observed from Section 12 of the MPA that the legislators had only contemplated that it would apply to couples who were legally married. In his view, extending the provision of the MPA to unmarried couples would create uncertainty, injustice, and impediments to property transactions and the rights of third parties, because married couples relinquish the right to deal with their property as sole owners upon marriage. Justice Halliburton considered the concept of marriage in our society, approving of the explanation made in the Myron dissent, where it was described as an institution and the basic framework upon which our society rests. He concluded that the distinction drawn between married and unmarried spouses was one that certainly created a disadvantage for those unmarried, and then assessed whether the distinction was based on irrelevant personal characteristics, such as those enumerated in Section 15 Sub 1 of the Charter. Relying upon the Myron dissent concerning marriage, he also acknowledged the majority comment that the failure of the parties to marry may not be a matter of free and independent choice, and stated at paragraph 21, quote, I would argue nonetheless that, as a general rule, it is a matter of freedom of choice. There are certain attributes of, quote, marriage, end quote, which have existed not only in our society, but in all societies since time out of memory. Such attributes encompass the public acknowledgement in the presence of community and family by two persons who enter into a binding, lifetime relationship, end quote. After reviewing the history of matrimonial property legislation, he observed that married women have been deprived of their independence and interest in their property in the past, but that men and women fare equally well under the MPA. Quote, to impose the regime created by this statute upon a person who chooses not to marry, and to do so retroactively, would be as likely to create injustice as to resolve it. End quote. Paragraph 22. He referred to my reasoning in M and H, where I observed at paragraph 289, quote, the comparison is best made not with married couples whose status was consensually acquired, but with unmarried cohabiting couples, end quote. He stated at paragraph 23, quote, from that brief quotation, I would argue that the property regime imposed by the Matrimonial Property Act is one which is or ought to be consciously acquired by the consent of the parties contracting to marry and knowing the statutory and other legal implications of doing so, end quote. Although he concluded that Walsh had not suffered discrimination on the basis of Section 15 Sub 1, Justice Halliburton considered at paragraph 26 whether the impugned section would be saved by Section 1 of the Charter, employing the Oakes test, as recently reiterated in M and H Supra, quote, The principle is that the objective of the legislation must be of sufficient importance to override the constitutional right which is impaired by the statute. The objective must be, quote, pressing and substantial, and must be evaluated or weighed in terms of the importance of these two competing values. Specifically referring to M and H, the court has said, where the violation results from, quote, under inclusion, end quote, the object of the legislation as a whole must be considered. In the case of the Matrimonial Property Act, the announced purpose is to regulate property rights between two parties to marriage. As will be clear from earlier comments, quote, marriage, end quote, as contemplated, refers to the status gained by persons who go through a legally authorized and recognized form of matrimony. The statute is intended to regulate the property rights of the parties during marriage as well as on marriage breakdown. It orders the presumptions which apply in the event of a division of marital assets and sets out guidelines for determining which assets of one of the parties is a marital asset and which are not. The ultimate goal of the legislation is to provide, emphasis, a framework for property ownership by the parties to a marriage which will afford certainty and predictability to both the marriage partners and third parties dealing with them, and emphasis. It is this aspect of, emphasis, certainty and predictability, and emphasis, which is the objective, which is, quote, pressing and substantial, end quote. The regime permits parties to engage in commerce, utilizing their own separate resources without impairment. It permits third parties to understand they are dealing with a marriage partner with confidence, ellipses. I would observe that, unlike the circumstances reviewed in M and H, where the Ontario Family Law Act was considered, the Matrimonial Property Act is not concerned with the support of spouses on marriage breakdown, nor with the maintenance of children. Its concern is exclusively with the division of wealth which one of the parties has acquired, either before or during the marriage, and sets out guidelines to assist in determining whether that wealth continues to be separate property or whether it becomes common property of the parties. Emphasis in the original. End quote. Justice Halliburton noted that certain other legislation recognized rights of unmarried couples, and that they were free to enter into an agreement to share property or to acquire property jointly. Likewise, he reasoned, they should be free to choose not to share their property. In his view, the impugned law is rationally connected to the objective of providing certainty and stability to property issues between married spouses. He next considered whether the rights of the respondent Walsh were impaired no more than necessary in order to accomplish the statutory objective. He noted that the stated intentions of the legislation are to strengthen the role of family in society and to provide for an orderly settlement upon marriage termination, recognizing household management and financial support as joint responsibilities. He observed that no other legislatures accord property rights to unmarried cohabitants, and that many uncertainties exist with respect to common law relationships. He noted that the result sought by the respondent was a shift of the burden of proof of property entitlement from one party to the other, so that there would be a presumption of equal sharing. He held at paragraph 31, quote, the deleterious effects of requiring a person in the position of the present applicant to establish her entitlement to share in the property held by the respondent is outweighed by the values of the scheme, which, as I have said, provides certainty and predictability for persons who are legally married. End quote. Justice Halliburton concluded that marital status was not analogous or protected ground under Section 15 sub 1 of the Charter, that the exclusion of common law spouses from the definition of, quote, spouse, end quote, in Section 2 sub G of the MPA did not constitute discrimination, and that if it were, it was demonstrably justified pursuant to Section 1. B. Nova Scotia Court of Appeal, 2000. On appeal, the Crown conceded that since the MPA applies only to married spouses, there was differential treatment pursuant to Section 15 sub 1 of the Charter, and that marital status is an analogous ground of discrimination. Its principal submission was that the differential treatment is not discriminatory, and if it is, then it is saved by Section 1 of the Charter. Justice Flynn, for the court, referred to Law in Canada, Minister of Employment and Immigration, 1999, where Justice Iacobucci summarized the approach to Section 15, Sub 1 analysis. Justice Flynn then reviewed the Law Reform Commission's report on the Nova Scotia matrimonial property regime, which permits each spouse to retain property in his or her name and to dispose of it without the consent of the other, with the exception of the matrimonial home. A right to equal division of property only arises on marriage breakdown. See Law Reform Commission of Nova Scotia, Final Report, Reform of the Law Dealing with Matrimonial Property in Nova Scotia, published 1997. Justice Flynn held that on the basis of Myron, the Chamber's judge was in error, concluding that marital status was not an analogous ground. He then considered whether the differential treatment of the respondent Walsh by the MPA was discrimination within the meaning of Section 15, Sub 1 of the Charter, referring to the majority judgment in M and H, which in turn relied upon law, particularly where it was stated at paragraph 60, quote, all of that individual's or that group's traits, history, and circumstances must be considered in evaluating whether a reasonable person in circumstances similar to those of the claimant would find that the legislation which imposes differential treatment has the effect of demeaning his or her dignity. Justice Flynn noted that in making this determination, the court is required to take into account other contextual factors such as pre-existing disadvantage, stereotyping, or prejudice experienced by the group in issue, the relationship between the grounds and the claimant's characteristics and circumstances, the ameliorative purpose or effect of the legislation, which may establish that human dignity has not been violated, and the nature of the interest affected. As Justice Iacobucci stated in the law case at paragraph 83, quote, in every case, though, a court's central concern will be whether a violation of human dignity has been established in light of the historical, social, political, and legal context of the claim, end quote. Within these guidelines, Justice Flynn turned to an analysis of Walsh's discrimination claim. Justice Flynn came to the conclusion that a reasonable person in circumstances similar to those of the respondent Walsh would find that the MPA, which imposes differential treatment, has the effect of demeaning the respondent's dignity, resulting in a violation of Section 15, Sub 1. In his opinion, the MPA perpetuated the view that unmarried spouses are less worthy of value as members of Canadian society, sufficient to establish an infringement of Section 15, Sub 1. In arriving at this decision, Justice Flynn considered that the respondent's relationship had all the hallmarks of a marriage, with the exception of a formal ceremony, that provisions in other legislation provide for support and occupation rights for unmarried spouses, and that the loss suffered by unmarried cohabitants of the presumption of equal sharing of property was, by reason only of their marital status. He recognized that common law spouses have the right to deal with their property in an agreement, but stated that the problem in this is that both parties must agree to the terms. He noted that, while the preamble to the statute recognizes the contribution of both spouses to the economic growth and survival of the family, see Clark and Clark, 1990, this contribution is unrecognized when made by an unmarried spouse. Justice Flynn examined the position of common law spouses within two of the contextual factors identified by Justice Iacobucci in the law case: pre-existing disadvantage and the nature of the interest affected. He referred to the reasoning of Justice McLaughlin, as she then was, in Myron, wherein she recounted how an unmarried spouse has historically been regarded as less worthy than a married spouse, resulting in the denial of many benefits. Justice Flynn reasoned that the fact that some benefits have been accorded to unmarried partners in a recognition of the fact that it is often wrong to deny equal benefit of the law because a person is not married. Justice Flynn rejected Crown submissions that, because married persons only enjoy a presumption of a 50% entitlement, there is no denial of an equal benefit. He noted the words of Justice Corey in M and H at paragraph 66, quote, The type of benefit salient to the Section 15 Sub 1 analysis cannot encompass only the conferral of an economic benefit. It must also include access to a process that could confer an economic or other benefit." End quote. He further rejected the Crown's position that Myron could be distinguished on the basis that, in that case, no other avenue was open to the unmarried spouses to obtain the insurance benefits, whereas, in the present case, Walsh may advance a claim using a constructive and resulting trust. Justice Flynn noted the difficulties inherent in pursuing these remedies. With respect to the Crown's argument that the presumptive entitlement in the MPA does not deal with the merit of the relationship and therefore does not go to human dignity, Justice Flynn concluded at paragraph 50 that the respondent's, quote, "dignity is violated because her relationship with Bonna is considered less worthy of recognition than the relationship of a married couple, and as a result, she is denied access to the benefits of the MPA." End quote. Having found the MPA discriminatory, Justice Flynn proceeded with the Section 1 analysis. He relied upon the framework established in Vriand and Alberta, 1998, and considered that the legislation as a whole, the impugned provisions, and the omission itself must all be taken into account in determining whether the objective is pressing and substantial. He noted that the inclusion of unmarried spouses in the legislation would have no impact on either married spouses or financially on the government. He rejected the statement in the preamble that one of its purposes was to, quote, "strengthen the role of the family in society," end quote, because its functional purpose is to provide for the resolution of property disputes upon termination of marriage. Justice Flynn noted that the Law Reform Commission of Nova Scotia reported that the MPA, by deeming contributions to a marriage to be equal, had recognized women's contributions to the economic growth and survival of the family, and, in that regard, the legislative purpose is pressing and substantial. In his view, however, the exclusion of unmarried spouses could not be linked to any clear objective or purpose that was pressing and substantial. He observed that the Commission recommended changes to the MPA to extend its benefits to any two adults who have cohabitated for at least a year, quote, "in a personal relationship in which one provides personal or financial commitment and support of a domestic nature for the benefit of the other," end quote, paragraph 65. He dismissed the Crown's argument that marriage and cohabitation are different and should be accorded different treatment, referring to the judgments in Petkus and Becker, 1980, and Peter and Beblow, 1993. The Crown's position that marriages are more stable as a justification for the differential treatment was similarly rejected, because there was no evidence to substantiate this argument. In Justice Flynn's view, stability, quote, "is hardly justification for providing that only married persons should have the benefits of legislation," end quote, paragraph 70. He observed the growing trend of common law families across Canada and stated at paragraph 73, quote, "The Crown also submits that any interference with the present distinction which is made between married couples and those in a common law relationship would interfere with the right to individual autonomy of those who do not wish to marry. In my view, providing those in a common law relationship with the ability to contract out of the MPA is of far less consequence than denying all others in a common law relationship the benefits of the MPA," end quote. Justice Flynn referred to other provincial legislation extending benefits to common law spouses and noted that the Human Rights Act of Nova Scotia 1989 prohibits discrimination on the basis of marital status. He reasoned at paragraph 76, quote, "The Crown has not provided any satisfactory explanation as to why it is pressing and substantial to exclude persons in a common law relationship from the provisions of the MPA, while at the same time including them on the same basis as married persons in other provincial legislation," end quote. Finally, he held that any problems with respect to conveyancing and estate matters which could create uncertainty and affect the rights of third parties with respect to extending property rights to unmarried spouses could be overcome with carefully drafted legislation. In his view, this practical problem is, quote, "not so insurmountable as to justify what has been determined in these reasons by a violation of Section 15 Sub 1 of the Charter," End quote, paragraph 78. He concluded that the Crown had failed to demonstrate that the exclusion of common law spouses from the provision of the MPA was, quote, pressing and substantial, end quote, paragraph 79. In terms of a remedy, he declined to read into the legislation a definition of, quote, spouse, end quote, that included unmarried cohabitants and opted to declare Section 2 sub G as having no force or effect, suspending the effect of the declaration for a period of 1 year to, quote, enable the legislature to devise a new criteria for eligibility under the MPA, including whatever transitional provisions may be deemed necessary, and to pass new legislation that meets the constitutional requirements of Section 15 sub 1 of the Charter, end quote, paragraph 85. Issues. By order of the Chief Justice dated June 25, 2001, the following constitutional questions were stated for this court's consideration. 1. Does Section 2 sub G of the Matrimonial Property Act of Nova Scotia discriminate against heterosexual unmarried cohabitants, contrary to Section 15 sub 1 of the Charter? 2. If the answer to question 1 is, quote, yes, end quote, is the discrimination a reasonable limit prescribed by law which can be demonstrably justified in a free and democratic society under Section 1 of the Charter? Analysis. In the law case, this court set out the test for determining whether an impugned statute violates the equality guarantee. Justice Iacobucci formulated a three-part inquiry as follows at paragraph 88 at pages 548 to 549. Quote, accordingly, a court that is called upon to determine a discrimination claim under Section 15 sub 1 should make the following three broad inquiries. A. Does the impugned law, A, draw a formal distinction between the claimant and others on the basis of one or more personal characteristics, or B, fail to take into account the claimant's already disadvantaged position within Canadian society, resulting in substantively differential treatment between the claimant and others on the basis of one or more personal characteristics? B. Is the claimant subject to differential treatment based on one or more enumerated and analogous grounds? And C. Does the differential treatment discriminate by imposing a burden upon or withholding a benefit from the claimant in a manner which reflects the stereotypical application of presumed group or personal characteristics, or which otherwise has the effect of perpetuating or promoting the view that the individual is less capable or worthy of recognition or value as a human being or as a member of Canadian society, equally deserving of concern, respect, and consideration? End quote. There is little debate in this case with respect to the first two broad inquiries. Firstly, as Justice Flynn correctly notes, the MPA extends only to persons who are legally married and does not extend to persons in a common law relationship. The appellant concedes that the MPA provides differential treatment for the purpose of Section 15 sub 1. Secondly, although marital status is not an enumerated ground, this court in Myron has stated clearly that marital status is an analogous ground on which a claim of discrimination can be made. Following her review of the numerous factors supporting the view that marital status is an analogous ground of discrimination, Justice McLaughlin found as follows at paragraph 156, quote, these considerations taken together suggest that denial of equality on the basis of marital status constitutes discrimination within the ambit of Section 15 sub 1 of the Charter. If the evil to which Section 15 sub 1 is addressed is the violation of human dignity and freedom by imposing limitations or disadvantages on the basis of the stereotypical application of presumed group characteristics, rather than on the basis of individual capacity, worth, or circumstance, then marital status should be considered on an analogous ground. The essential elements necessary to engage the overarching purpose of Section 15 sub 1, violation of dignity and freedom, and historical group disadvantage, and the danger of stereotypical group-based decision-making are present and discrimination is made out. End quote. The Crown also concedes that marital status is an analogous ground. It is with respect to the third broad inquiry that the appellant argues the Court of Appeal erred. In the law case, Justice Iacobucci set out 4 non-exhaustive factors for consideration of whether impugned legislation violates a claimant's human dignity. Quote, A. Pre-existing disadvantage, stereotyping, or vulnerability of the claimant. B. Correspondence between the claim and the actual need or circumstances of the claimant. C. The ameliorative purpose or effect of the impugned law on the other groups in society. D. The nature and scope of the interest affected. In considering the 4 contextual factors, the Court of Appeal held pre-existing disadvantage and the nature of the interest affected to be the most relevant. The appellant argues that the Court of Appeal failed to fully consider the nature of the relationships involved before determining that Walsh's dignity was infringed. It points out that the court did not make any finding with regard to whether the parties had, upon entering into or during their relationship, any intention to contribute to one another's property acquisition, or whether they deliberately avoided marriage and the consequences that flow from it. That is to say, the appellant argues that there is no evidence on which to conclude that the respondent considered herself disadvantaged by the non-marriage. Moreover, the appellant argues that it would in fact be unfair to make assumptions about all relationships and to impose a matrimonial property regime on persons who have chosen not to marry. It urges this court to consider the exclusion of unmarried persons from the MPA as arising out of respect for the autonomy and self-determination of those who choose not to marry. I agree with the appellant that the examination of pre-existing disadvantage and the nature of the interest affected is dependent on the proper characterization of the relationships involved. In my view, the most important aspect of this question is not whether the situation in which Walsh and Bonner find themselves at the time of the trial was similar to that of married persons, but whether persons entering into a conjugal relationship without marrying are in fact entering into a relationship on the same terms as persons who marry. On the other, we have persons who cannot be presumed to have accepted all of the obligations of marriage. This is a significant aspect of the context in which the respondent's claims of discrimination arise. The respondent Walsh argues, and the Court of Appeal held, that the MPA, by excluding unmarried spouses from its purview, serves to perpetuate the view that unmarried couples are less deserving of recognition and respect in Canadian society. I cannot agree. As this court reasoned in the law case, consideration of whether the differential treatment is discriminatory must always be done in purposive and contextual manner. As Justice Iacobucci noted at paragraph 60, quote, "Although I stress that the inquiry into whether legislation demeans the claimant's dignity must be undertaken from the perspective of the claimant and from no other perspective, a court must be satisfied that the claimant's assertion that differential treatment imposed by legislation demeans his or her dignity is supported by an objective assessment of the situation. All of the individual's or the group's traits, history, and circumstances must be considered in evaluating whether a reasonable person in circumstances similar to those of the claimant would find that the legislation which imposes differential treatment has the effect of demeaning his or her dignity." Justice Iacobucci noted that the evaluation of the contextual factors must be conducted from the position of the claimant. He also held that this evaluation has both an objective and subjective component. As he later phrased it in Lovelace and Ontario, 2000, at paragraph 55, quote, "The question to be asked is whether, taking the perspective of, quote, a reasonable person in circumstances similar to those of the claimant, who takes into account the contextual factors relevant to the claim," end quote, law case at paragraph 88, "the law has the effect of demeaning a claimant's human dignity." See Egan and Canada, 1995, per Justice Leroux Dubé at paragraph 56, end quote. In the present case, then, the inquiry can be stated as whether a reasonable heterosexual unmarried cohabiting person taking into account all of the relevant contextual factors, would find the MPA's failure to include him or her in its ambit has the effect of demeaning his or her dignity. As this court has stated on numerous occasions, the equality guarantee is a comparative concept. It requires the location of an appropriate comparator group from which to assess the discrimination claim. The two comparator groups in this case are married heterosexual cohabitants, to which the MPA applies, and unmarried heterosexual cohabitants, to which the MPA does not apply. Although in some cases certain functional similarities between these two groups may be substantial, in this case it would be wrong to ignore the significant heterogeneity that exists within the claimant's comparator group. The contextual analysis of the respondent's claim reveals that reliance solely on, quote, certain functional similarities, end quote, between the two groups does not adequately address the full range of traits, history, and circumstances of the comparator group of which the claim is a member. It is indeed clear from the evidence that some cohabitants have specifically chosen not to marry and not to take on obligations ascribed to persons who choose the status. See Z-Wu, Cohabitation, an alternative form of family living, published in 2000, at pages 105 to 6, 116, 120 to 121. And see also Alberta Law Research and Reform Institute, Survey of Adult Living Arrangements, a technical report, 1984, at pages 64 to 72. In his study of alternative family forms, Professor Wu makes several conclusions, which include 1. That common law relationships tend to be much shorter duration than married relationships. 2. That cohabitation can be, quote, a trial marriage, end quote. 3. That cohabitation can be a deliberate substitute for a legal marriage. 4. That persons who do not marry tend to have less conventional attitudes toward marriage and family and reject the institution of marriage on the basis of personal choice. These findings are indicative not only of the differences between married couples and cohabitating couples, but also of the many differences among unmarried cohabitants with regard to the manner in which people choose to structure their relationships. This court has recognized both the historical disadvantage suffered by unmarried cohabitating couples as well as the recent social acceptance of this family form. As Justice McLaughlin noted in Myron at paragraph 152, there is ample evidence that unmarried partners have often suffered social disadvantage and prejudice. Historically, in our society, the unmarried partner has been regarded as less worthy than the married partner. The disadvantages inflicted on the unmarried partner have ranged from social ostracism through denial of status and benefits. In recent years, the disadvantage experienced by persons living in illegitimate relationships has greatly diminished. Those living together out of wedlock no longer are made to carry the scarlet letter. Nevertheless, the historical disadvantage associated with this group cannot be denied. End quote. Since Myron, significant legislative change has taken place at both the federal and provincial levels. Numerous statutes that confer benefits on married persons have been amended so as to include within their ambit unmarried cohabitants. Nevertheless, social prejudice directed at unmarried partners may still linger, despite those significant reforms. In light of those social prejudices, this court recognized in Myron that one's ability to access insurance benefits was not reducible to simply a matter of choice. Justice Leroux Dubé, in her concurring judgment, reasoned as follows at paragraph 102. Quote, "To recapitulate, the decision of whether or not to marry is most definitely capable of being a very fundamental and personal choice. The importance actually ascribed to the decision to marry, or alternatively, emphasis, not, and emphasis, to marry, depends entirely on the individuals concerned. For a significant number of persons in so-called non-traditional relationships, however, I dare say that notions of choice may be illusory. It is inappropriate, in my respectful view, to condense the forces underlying the adoption of one type of family unit over another into a simple dichotomy between choice or no choice. Family means different things to different people, and the failure to adopt the traditional family form of marriage may stem from a multiplicity of reasons. All of them equally valid, and all of them equally worthy of concern, respect, consideration, and protection under the law." End quote. Where the legislation has the effect of dramatically altering the legal obligations of partners as between themselves, choice must be paramount. The decision to marry or not is intensely personal and engages a complex interplay of social, political, religious, and financial considerations by the individual. While it remains true that unmarried spouses have suffered from historical disadvantage and stereotyping, it simultaneously cannot be ignored that many persons in circumstances similar to those of the parties, that is, opposite-sex individuals in conjugal relationships of some permanence, have chosen to avoid the institution of marriage and the legal consequences that flow from it. As Eichler posited, treating all common law relationships like legal marriages in terms of support obligations and property division ignores the very different circumstances under which people may enter into a common law union. If they choose to marry, they make a positive choice to live under one type of regime. If they have chosen not to marry, is it the state's task to impose a marriage-like regime on them retroactively? End quote. See M. Eichler, Family Shifts, Family Policies and Gender Equality, published in 1997 at page 96. To ignore these differences among cohabiting couples presumes a commonality of intention and understanding that simply does not exist. This effectively nullifies the individual's freedom to choose alternative family forms and to have that choice respected and legitimated by the state. Examination of the context in which the discrimination claim arises also involves a consideration of the relationships between the grounds and the claim's characteristics or circumstances. As Justice Iacobucci described it in the law case at paragraph 70, quote, "It is thus necessary to analyze in a purposive manner the ground upon which the Section 15.1 claim is based when determining whether discrimination has been established. As a general matter, legislation which takes into account the actual needs, capacity, or circumstances of the claimant and others with similar traits in a manner that respects their value as human beings and members of Canadian society will be less likely to have a negative effect on human dignity. Ellipsis. The fact that the impugned legislation may achieve a valid social purpose for one group of individuals cannot function to deny an equality claim where the effects of the legislation upon another person or group conflict with the purpose of Section 15 sub 1 guarantee. In line with the reasons of Justice McIntyre and Justice Sapinka, I simply mean to state that it will be easier to establish discrimination to the extent that impugned legislation fails to take into account a claimant's actual situation, and more difficult to establish discrimination to the extent that legislation properly accommodates the claimant's needs, capacities, and circumstances." End quote. Consideration of the extent to which impugned legislation properly accommodates the claimant's circumstances begins with the MPA and the changes it brought about. The purpose of the MPA is revealed in its preamble and through the debates of the House of Assembly at the time it was introduced. On second reading of the MPA bill on the 8th of May, 1980, the legislative purpose was described as follows. Quote, "The intent and purpose of the legislation, Mr. Speaker, is to be found in the preamble, ellipsis. The intent by virtue of the introduction and hopefully, emphasis, the ultimate passage of this legislation is to establish clearly that marriage is a partnership and that the partnership carries with it an understanding of equality," end quote. And equality in all senses and as it relates to the particular piece of legislation, equality at the time any such marriage should come to an end by reason either of separation, divorce, or upon death. End quote. See Nova Scotia House of Assembly, Debates and Proceedings, 80-44, May the 8th, 1980 at page 2011. The MPA created a regime of, quote, deferred sharing, end quote, replacing the regime of absolute separate property. The new legislative scheme deems married persons to have agreed to an economic partnership wherein both pecuniary and non-pecuniary contributions to the marriage partnership are considered to be of equal worth. The MPA provides, inter alia, that property acquired by each spouse before and during the marriage constitutes a pool of assets, which may be divided, regardless of legal title, in equal shares upon marriage breakdown, divorce, or death of either spouse. It also provides each spouse with an equal right of possession in the matrimonial home, without regard to title, and provides that no sale or mortgage of the matrimonial home may occur without the consent of both spouses. See Law Reform Commission of Nova Scotia at pages 5 to 7. As a whole, then, the MPA is designed to ensure the economic partnership between married persons by affording protections to the non-title holding spouse, both during the marriage and at its end, whether due to divorce or death. The respondent Walsh is in noting that the MPA was designed to remedy the wrongs of the past and to support the equality of both spouses as a result of their joint commitment to share equally in the matrimonial assets. As Justice Wilson reasoned in the Clark case at page 807, quote, "Thus, the Act supports the equality of both parties to a marriage and recognizes the joint contributions of the spouses, be it financial or otherwise, to that enterprise. The Act goes further and asserts that, during this joint contribution, both parties are entitled to share equally in the benefits that flow from the union, the assets of marriage. The Act is accordingly remedial in nature. It was designed to alleviate the inequalities of the past when the contribution made by the women to the economic survival and growth of the family was not recognized." End quote. This remedying of inequities is recognized in the MPA's preamble and is achieved by the matrimonial property regime that it creates. Although the respondent focuses her argument on the provision in the MPA that confers upon married spouses the right to apply for a presumptive equal division of matrimonial assets on marriage breakdown, it must be remembered that the presumption of equal division of property is only one part of the overall scheme. The MPA also provides other significant benefits and imposes significant obligations on the spouses: a right of possession to the matrimonial home, protection against disposition of the matrimonial home, a right to redeem the interest in the matrimonial home vis-a-vis execution creditors, a right to apply for division of assets on the death of a spouse, in addition to rights by way of will or intestacy. Moreover, even the division of matrimonial assets brings with it significant obligations to the spouses. The manner in which the property division is achieved is to calculate the total value of the matrimonial assets and subtract from the amount the total value of the matrimonial debts, without regard in both cases to the title in whom these assets or liabilities rest. Thus, the MPA, by deeming all marriages to be economic partnerships, imposes a significant alteration to the status quo of an individual's propriety rights and obligations. Moreover, these statutorily created propriety restrictions and obligations arise as at the time of the marriage and continue through the duration of the marriage until separation or death. The decision to marry, which necessarily requires the consent of each spouse, encapsulates within it the spouse's consent to be bound by the property regime that the MPA creates. Unmarried cohabitants, on the other hand, maintain their respective propriety rights and interests throughout the duration of their relationship and at its end. These couples are free to marry, enter into domestic contracts, to own property jointly. In short, if they so choose, they are able to access all of the benefits extended to married couples under the MPA. Though my conclusion in this case in no way is dependent upon the existence of the LRA, this new legislation offers another means by which unmarried cohabitants can access these benefits. The LRA is tailored to persons who, for a myriad of reasons, choose not to marry, but who nevertheless consent to be bound legally to the same regime of economic partnership with all of the rights and obligations that it entails. The general principle is that, without taking some unequivocal consensual action, these cohabitating persons maintain the right to deal with any and all of their property as they see fit. The MPA, then, can be viewed as creating a shared property regime that is tailored to persons who have taken a mutual positive step to invoke it. Conversely, it excludes from its ambit these persons who have not taken such a step. This requirement of consensus, be it through marriage or registration of a domestic partnership, enhances rather than diminishes respect for the autonomy and self-determination of unmarried cohabitants and their ability to live in relationships of their own design. As Justice Yakibushi phrased in the law case at paragraph 102, quote, "The law functions not by the device of stereotype, but by distinctions corresponding to the actual situation of individuals it affects." End quote. Relying mostly on the decisions of this court in Myron and M&H, the respondent Walsh says that even if some common law spouses may benefit from the inapplicability of the MPA to their relationship breakdown, this does not address the statute's effect in perpetuating the view that an unmarried spouse is less entitled to recognition and respect than a married spouse. The respondent insists that not all members of the claimant group need be negatively affected, that the potential denial of the right to equality to any member of the group suffices. Following the reasoning of Justice McLaughlin in Myron, Walsh argues that there may be many factors that preclude certain individuals from marrying and thereby availing themselves of the MPA, even though their relationships have all the functional markings of a marriage. By excluding from its ambit unmarried couples, whom the respondent submits are the functional equivalents of married couples, the MPA has the effect of perpetuating the view that these alternative family forms are less deserving of recognition and respect. In Myron, this court held the denial of insurance benefits to unmarried spouses to be discriminatory within the meaning of Section 15 sub 1. In that case, the impugned legislation denied automobile insurance benefits to persons in circumstances similar to married persons. Short of agreeing to marry, the cohabitants had no ability to control the availability to each other of the benefits. Moreover, the extension or denial of these benefits had no impact on the rights and obligations of the spouses vis-a-vis each other. The discriminatory distinction at issue in Myron concerned the relationship of the couple as a unit to third parties. The marital status of the couple should have no bearing on the availability of the benefit. In the present case, however, the MPA is primarily directed at regulating the relationship between the parties to the marriage itself. Parties who, by marrying, must be presumed to have a mutual intention to enter into an economic partnership. Unmarried cohabitants, however, have not undertaken a similar unequivocal act. I cannot accept that the decisions live together without more is sufficient to indicate a positive intention to contribute to and share in each other's assets and liabilities. It may very well be true that some, if not many, unmarried cohabitants have agreed as between themselves to live as economic partners for the duration of the relationship. Indeed, the factual circumstances of the parties' relationship bear this out. It does not necessarily follow, however, that these same persons would agree to restrict their ability to deal with their own property during the relationship or to share in all of the other's assets and liabilities following the end of the relationship. As Eichler points out at pages 95 to 96, quote, "There is a distinct difference between a young couple living together, having a child together, and then splitting up, and an older couple living together after they have raised children generated with another partner. If a middle-aged couple decide to move in together at the age of 55 and to split at age 60, and if both of them have children in their 30s, the partners may wish to protect their assets for themselves and for their children, with whom they have had a close relationship for over 30 years, rather than with a partner with whom they were associated for 5 years. In my view, people who marry can be said to freely accept mutual rights and obligations. A decision not to marry should be respected because it also stems from a conscious choice of the parties. It is true that the benefits that one can be deprived of under Section 15 sub 1 analysis must not be read restrictively and can encompass the benefit of a process or procedure as recognized in M and H. It has not been established, however, that there is a discriminatory denial of a benefit in this case because those who do not marry are free to take steps to deal with their personal property in such a way as to create equal partnership between them. If there is need for a uniform and universal protective regime independent of choice of matrimonial status, this is not a Section 15 Sub 1 issue. The MPA only protects persons who have demonstrated their intention to be bound by it and have exercised their right to choose. The respondent Walsh argues that the choice to marry, to enter into a domestic contract, or to register a partnership under the LRA still does not address her situation, nor does it address the circumstances of those individuals whose unmarried partner either refuses to marry or register their domestic partnership. For these persons, as Walsh argues, the decision is not entirely within their control. Similarly, she argues that maintaining the propriety status quo in unmarried cohabiting relationships unduly disadvantages both the non-title holding partner, who have historically been women, as well as the children of the relationship. The respondent argues that protection of women and children from the potentially dire economic consequences of marriage breakdown is one of the main purposes of the MPA. Excluding unmarried cohabitants, then, constitutes a denial of protection of women in conjugal relationships and the children of those relationships, the person whom the legislation was specifically designed to protect. On this basis, the respondent submits that the only constitutionally acceptable formula is to extend the ambit of the MPA to all unmarried cohabitants, while providing consenting couples the opportunity to opt out, as the current MPA does with married couples. The problem with that proposition, in my view, is that it eliminates an individual's freedom to decide whether to make such a commitment in the first place. Even if the freedom to marry is sometimes illusory, does it warrant setting aside an individual's freedom of choice and imposing on her a regime that was designed for persons who have made an unequivocal commitment encompassing the equal partnership described in the MPA? While there is no denying that inequities may exist in certain unmarried cohabiting relationships, and that those inequities may result in unfairness between the parties on relationship breakdown, there is no constitutional requirement that the state extend the protections of the MPA to those persons. The issue here is whether making a meaningful choice matters, and whether unmarried persons are prevented from taking advantage of the benefits of the MPA in an unconstitutional way. Persons unwilling or unable to marry have alternative choices and remedies available to them. The couple may choose to own their property jointly and/or to enter into a domestic contract that may be enforced pursuant to the Maintenance and Custody Act of Nova Scotia and the Maintenance Enforcement Act of Nova Scotia. These couples are capable of accessing all of the benefits of the MPA through the joint registration of a domestic partnership under the LRA. It is true that certain unmarried couples may also choose to organize their relationship as an economic partnership for the period of their cohabitation. Similarly, some couples, without making a public and legally binding commitment, may simply live out their lives together in a manner akin to marriage. In these cases, the law has evolved to protect those persons who may be unfairly disadvantaged, and as a result of the termination of their relationship. Firstly, provincial legislation provides that an unmarried cohabitant or, quote, common law partner, end quote, may apply to a court for an order of maintenance or support. See the Maintenance and Custody Act, Section 3. The court is empowered to take into consideration a host of factors pertaining to the manner in which the parties organize their relationship, as well as the particular needs and circumstances of both parties. For those couples who have not made arrangements regarding their property at the outset of their relationship, the law of constructive trust remains available to address inequities that may arise at the time of the dissolution. The law of constructive trust developed as a means of recognizing the contributions, both pecuniary and non-pecuniary, of one spouse to the family as assets to the title of which was vested wholly in the other spouse. See Rathwell and Rathwell, 1978. After the enactment of the MPA, the law of constructive trust remained and remains a recourse for unmarried partners who find themselves unfairly disadvantaged vis-a-vis their former partner. Those situations where the fact of economic interdependence of the couple arises over time are best addressed through remedies like constructive trust, as they are tailored to the party's specific situation and grievances. In my view, where the multiplicity of benefits and protections are tailored to the particular needs and circumstances of the individuals, the essential human dignity of unmarried persons is not violated. All of these factors support the conclusion that the extension of the MPA to married persons only is not discriminatory in this case, as the distinction reflects and corresponds to the differences between those relationships, and it respects the fundamental personal autonomy and dignity of the individual. In this context, the dignity of common law spouses cannot be said to be affected adversely. There is no deprivation of a benefit based on stereotype or presumed characteristics, perpetuating the idea that unmarried couples are less worthy of respect or valued as members of Canadian society. All cohabitants are deemed to have the liberty to make fundamental choices in their lives. The object of Section 15 sub 1 is respected. Finally, it is important to note that the discriminatory aspect of the legislative distinction must be determined in light of charter values. One of those essential values is liberty, basically defined as the absence of coercion and the ability to make fundamental choices with regard to one's life. See the Queen and Big M Drug Mart Limited, 1985. Limitations imposed by this court that serve to restrict this freedom of choice among persons in conjugal relationships would be contrary to our notions of liberty. Accordingly, I do not find that Section 2 sub G of the MPA violates Section 15 sub 1 of the Charter. Having found no discrimination in this particular case, it is unnecessary to proceed with a Section 1 analysis. Disposition. I would allow the appeal and answer the constitutional question as follows. 1. Does Section 2 sub G of the Matrimonial Property Act of Nova Scotia discriminate against heterosexual unmarried cohabitants, contrary to Section 15 sub 1 of the Charter? Answer. No. If the answer to question 1 is yes, is the discrimination a reasonable limit prescribed by law which can be demonstrably justified in a free and democratic society under Section 1 of the Charter? Answer. No answer is required.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.